Good morning, everyone. It is 9 a.m. and I'd like to call to order the meeting of the Rules, Policy, and Industrial Relations Committee of June 27, 2025. Before we begin, please note this meeting is being recorded. Welcome to my colleagues and everyone joining us here in person, as well as those listening on the phone. If you would like to provide public comment at today's meeting, and if you have not done so already, please let Thomas in the back of the room or Justine on the call-in line know what items you would like to speak on today. Madam Secretary, please begin by calling the roll.
Thank you and good morning, everyone. Let's start with Director Denley.
Here.
Garbarino.
Here.
Hardiman.
Here.
Hill.
Here.
Parr.
Present.
Fear. Vice Chair Moulton-Peters.
Here.
And Chair Hernandez is absent. President Cochran.
Here.
Thank you. For the Committee of the Quorum, you are also Committee of the Whole. Also in the room, we have Directors Giudice, Maston, Rabbit, Bordoni, and Snyder.
Okay. Thank you. We will move on to item number 3, which is to rescind resolutions number 2020-049 and 2023-010. Revise the strategic plan and authorize the general manager to take any other actions necessary to comply with the Federal Transit Administration Master Agreement, the Federal Highway Administration Grant Agreements, and the U.S. State Department of Transportation guidance. And General Manager Dennis Mulligan is here to present the report. And before I turn it over to our general manager, I just want to say we are running a very transparent and fair process here. We want to hear from everyone on all sides of this issue, and that is what we are here to do today. And so with that, General Manager Mulligan.
Thank you, Madam Chair, members of the board, members of the public. The item before you is precipitated by the change of administration in Washington, D.C. With the change in administration has come a flurry of executive orders, and the various federal departments are implementing those executive orders. Last month in my general manager's report, on the first page of that report, which was page 25 of that packet for those looking at it online, I highlight the recent changes in the White House executive orders as it pertains to the Federal Transit Administration. On April 24th of this year, the new Secretary of Transportation Duffy issued a memorandum to all grant recipients informing them that the terms and conditions of all U.S. DOT grants has changed. And the following day, on April 25th, the Federal Transit Administration issued a new master agreement, revision number 33, and I highlighted the specific problematic language from FTA master agreement number 33 in my general manager's report last month. We talked about it. It's on page 58 of the master agreement, and I have a link in that staff report for those that wish to see the totality of that master agreement. But it has 2 areas that are causing a lot of concern and consternation and challenges for transit agencies all across the country. The first is the grants that agencies sign in order to get federal money say the recipient will cooperate with federal officials in the enforcement of federal law, including cooperating with and not impeding U.S. Immigration and Customs Enforcement, ICE. That's a new requirement of all federal grants. It then goes on with respect to DEI saying that the Executive Order 14173, ending illegal discrimination and restoring merit-based opportunity, the recipient agrees that its compliance in all aspects with all applicable federal anti-discrimination laws is material to the government's payment decisions for the purposes of, and that quotes some arcane U.S. code. That arcane U.S. code is the Federal False Claims Act. Under the Federal False Claims Act, if you're deemed to have violated it, you have to pay triple damages. The Federal False Claims Act application to a grant agreement is, from a legal perspective, a novel approach, so it's unclear how the courts might ultimately rule on that. But then it goes on to say by entering into this agreement, the recipient certifies that it does not operate any programs promoting diversity, equity, and inclusion initiatives that violate any applicable federal anti-discrimination laws. As of recent, the U.S. Supreme Court and the federal government have interpreted DEI programs that are race-specific or sex-specific to be problematic. Today's paper, you heard there's an investigation of UC hiring practices that's underway. As recently as a couple of weeks ago, the U.S. Supreme Court ruled in an anti-discrimination case that you cannot treat one race, the majority race, different than a minority race. So the current federal government gets to interpret the various initiatives of transit agencies when they evaluate our grant applications. Then the staff report last month went on to say staff and the attorney are reviewing the new FTA Master Agreement 33, since in the coming months the district will receive revised new grant agreements from Federal Highway and FTA for a variety of different projects. With respect to grant agreements, as background for those listening in, The Bridge District operates bus and ferry service as well as own and operating the world's most famous bridge, and we spend a lot of federal money. When we buy new buses or new ferry boats, it's typically 80% Federal Transit Administration grants. When we seismically retrofit the bridge or build a suicide barrier of the bridge, it's generally federal funds that we use for the majority of the project costs. So with that, we have grant agreements that we need to sign. On the Federal Transit Administration side, we have some new certifications and assurances that we want to sign this afternoon, if we could, so that we can submit grant application paperwork on Monday. On the Federal Highway side, the Bridge District was very fortunate to receive a $400 million discretionary federal grant as part of a new bridge investment program as part of the bipartisan infrastructure law. That $400 million grant is to seismically retrofit the Golden Gate Bridge. We have a deadline to obligate that money by September 30th, or we will lose that grant. So time is an issue here. Our goal is to meet that deadline so we don't lose the money and award a construction contract this calendar year, putting hundreds of construction workers to work here on the Golden Gate Bridge during a period of time where I dare say construction is a little slow in San Francisco. So the question is, what do we do with this challenge? Well, we really have three options. The first option is we could bury our head in the sand, sign the grant agreement, and just move on. There's risk in that. The risk arises from the fact that we have countless policies, countless resolutions. A handful of those have some language that could be deemed problematic. We have some that call out specific races. That is not allowed pursuant to recent court rulings and, more importantly, by the federal government's people in charge. The initial arbitrator of whether our language is problematic or not are political appointees in Washington, D.C. So what's the risk? If we sign the grant agreement and do nothing, and then the federal government says, well, some of your language is problematic and is contrary to the grant. I read the language where it says the payment is contingent upon that. So they could stop payment, they could claw the money back, and they could try to pursue triple damages. Some organizations may choose to just sign the grant agreement and glide under the radar. They may be a smaller agency. We're the Golden Gate Bridge. There's no gliding under the radar for us. We are a symbol of our nation. Just to remind everybody that in the State of the Union address in January, the president only mentioned one bridge by name, the Golden Gate Bridge. So we don't have the luxury of gliding under the radar. If we choose option one, we're taking risks that the grant may not be awarded, that the grant may be clawed back, and we may have damages. The second option is we could choose litigation. Many organizations are choosing to sue. Generally speaking, the majority of those organizations that are choosing to sue really don't have a viable legal choice. Because if you have a police department, you have a state law that says you shall not cooperate with ICE. You may also have a local ordinance that says we're a sanctuary city. So the grant agreement says you will cooperate with ICE. So the only way you can sign that grant agreement is if you sue challenging that provision. Now, we're fortunate with respect to that issue because we do not have a police department. Our security forces are not sworn peace officers, so we have no conflict there. So we don't have to choose to sue. If you choose to sue, there are risks. The courts can take time. There's multiple layers of courts. And so if you choose to sue, you're trusting your fate to the third branch of the federal government, the judiciary. The federal judiciary are all appointed. It's important to note that it's likely to go all the way up to the Supreme Court. Our $400 million grant plus another $200 million in federal money we have in Caltrans, so $600 million to build that retrofit, the vast majority of the project funding will be drawn down over a 5 or 6 year period as we build the project. Well, during that period of time, the U.S. Supreme Court will likely weigh in on this matter. The question to the U.S. Supreme Court is, can the federal government condition a federal grant to require the grant recipient to comply with all federal laws, even when the federal law is in conflict with the state law or local ordinance? Now, since we have the choice, I would recommend that we not bet $400 or actually $600 million on this Supreme Court's answering that question in a way saying that we're not subject to all federal laws. But that is a risk, and every organization has to weigh their risk and choose what option they wish to pursue. The third option is what we have before you here today. We have lots of resolutions, lots of grants, and our recommendation is that as we review all of them, that the few that have problematic language that we undo, where we talk about race-specific things, we know that will be subject to scrutiny, and it will likely endanger our grants. It will likely lead to people wanting to claw back money. And I did say earlier that we are a symbol of our country. So staff feels that we should undo those things that are problematic, recognizing that it doesn't change who we are. We'll still wake up tomorrow morning and we'll be a great place to work. We'll still provide first-class customer service to people that ride our buses, ride our ferries, that use our bridge. And we'll still be a great vendor to work with. But that third option will mean that we can award a construction contract this calendar year and put hundreds of construction workers to work, but more importantly, to protect the bridge for future generations. As an organization, we're entrusted with protecting this bridge for the future, and this recommendation before you allows us to do that. So with that, I'm available to answer any questions.
Okay. Thank you, Dennis, for your report. I'm going to open now to board comments and questions. Yes, please.
Yeah, I had a question. So I know I briefly talked with Kim yesterday. I'm sorry he's not here today. And my first question is this, from a legal perspective, this is the analysis, so this is what's presented us today before us. And could you just speak a little bit on how that conclusion came about, what our risks are? Because I definitely, it's definitely one of these, a moral dilemma, and we're all, here to listen and learn and try to make the best informed.
Of course, yes. And we apologize that Kim's not here today. He had a medical emergency, but he's doing okay. So yes, we analyzed all of, we went back and looked at the resolutions, and we looked at the applicable law. And while we do not think that there's anything that's on the books that's illegal per se, we are not the final arbiters of this, and there is significant legal risk in our interpretation, as your general manager outlined, with leaving these particular resolutions and the strategic plan language on the books as is. And so we do concur with the recommendation of staff.
Okay. I guess I would follow up with, I did, as soon as I heard that, the headlines were awful. It was really painful. I got a lot of calls, and one of the first people I called was, and I wish Sabrina was here today. I know she's enjoying a vacation with, because she did chair a diversity committee. And I'm not speaking for her, but it was. I'm sorry she's not here because it's such a big issue around everything that she champions, that we champion as late, as in our other roles besides Sylvia Bridge. But I also have been, in this environment now for, we all have for 4 or 5 months, and I do see the risk of the $400 million. We worked so hard. We've been back to DC, Jerry. We've met with the DOT. We've under both administrations, we've jumped through different hoops, and we're still. Yesterday's report, it's $1.8 billion to this retrofit. This happened in Loma Prieta and all the things that came out of it, and we're still short some $100 million. And so that's definitely a huge concern for the workers, and for, that we also had a report on where things are in the financial system, and everything is so unknown from day to day to day to day. And anything that we love on the table, it's not good. And I've seen it, we're seeing it at High Speed Rail, under, the last administration when we were working on, offshore wind. We actually built diversity programs and pre-apprenticeship and trying to bring these things on. And we do the same thing here. And I guess I would say that, there's got to be a third way. And I know some of us talked about it, where we still can uphold our values. And I'm not completely comfortable with revoking the entire resolution and stuff like that, but there's got to be a way we can express our values without compromising ourselves. And our number one priority as bridge board members is, safety of the bridge, safety of the public. And we cannot leave any dollar on the table because, we don't know, things may change in 2 years, things may not change in 2 years, things may change in 4 years, things may not change. And we still have to, grab that money if we can. And whatever we can do, I know we're an intelligent group and a passionate group, and everybody that's I've worked with here, I know your values, and I'm looking forward to the rest of the conversation.
Thank you, Director. Director Giudice.
Yes, clearly the choices in front of us are horrible. That bridge does more than span a body of water, right? That bridge is a symbol, arguably the Statue of Liberty of the West Coast, truly. And I feel like when I was a kid, my dad was telling me this story about the steamroller, right? You can stand in front of the steamroller and you can get flattened. Or you can step aside, get into the cab, and disconnect the motor, right? And I think that there is another way. I have been thinking about this. Let's craft a new resolution, right? Let's craft a resolution that is based on our values. You know, that the district believes that every person has the right to be respected and to be safe. That the district and the board of directors show honor, compassion, and the qualities of character that support equal justice and due process for all. That the bridge is universally beloved, a universally beloved example of beauty, innovation. It stands as a beacon to the world that represents the way, the best of human endeavor, cooperation, and unity. Sorry, my scribble's a little garbled here. That the district commits our entire workforce to embrace a culture of belonging by building bridges, towards one another, not away, creating bonds of connection based on empathy, love for one another, and understanding. And certainly, as Dennis pointed out and as Chris pointed out, our culture is not going anywhere. It's here to stay. The California culture, which the bridge helped to cultivate, is here to stay. And so we're served with this dilemma. We have staff here, and I would put it to us as a board to take action right now and craft a new resolution to bring it back to this board to approve based on our guiding principles that does not conflict with the federal government. And I'll yield my time, Chair.
So, Director, are you making an amended motion?
I would be more than happy to make the motion. I make a motion that we excuse staff to draft a new resolution based on...
Can we have your notes?
I do have notes. If you can read them. Based on those principles and others. And I'm not a great, writer, but I'm sure that, you can expand upon this and bring us something back that we can vote on today that upholds our values but puts us in compliance with federal law.
So to clarify then, is that a motion that you approve this item going forward to the board with the understanding that the board meeting will come back with a typed motion passed out to everybody and read into the record?
Yes.
I'm just trying to make this work.
Yep.
Okay. All right. Is there any other discussion?
Is there a second on
There's
this?
a second on the motion.
I second. Okay, second. Other discussion. We do need to move to public comment that I want other board members. Okay. Yes.
I just want to thank you both for your comments and your articulation as someone who's living day to day with the threat of an ICE raid in my own workplace and the inhumanity that this administration represents and the injustice. I hearken back to what my elders said about World War II and what happened then. It's happening again. So I too support what you said. I think your option and option 3 take the wind out of their sails. Option 2 would have been like Christmas for them to take on the Golden Gate Bridge, and that can't happen at the detriment to so many people. We're crucifying people who are just trying to feed their families, and it's amoral. And it would be wonderful to be able to take a stand, but there would be no win-win in that situation right now. Someday. Thank you again.
Thank you, Director. Okay, if there's no other director, yes, Director Hill and then Director Thiel.
Thank you. I agree with everything you said. I'm wishing that way. But in reading all that's gone about interpreting the Supreme Court and all these other things, I don't think we have the talent to exactly make a word that they or a document by ourselves that would be clear, that would be acceptable. Let me put it that way. I have that fear. We wait for us, but the wording has to be very careful.
So I agree completely. So I think when this meeting adjourns before the board meeting, legal counsel and myself will take the notes from Director Giudice, and then we'll take the original George Floyd resolution, most of which we can retain, and we'll, combine it really quick, cut and paste, and bring something back, but it'll go through legal scrutiny. It will not call out any specific races or use certain words that are problematic.
Thank you.
Yeah, just to add to that, that language has been previously vetted, so I think that would be a good starting place.
Director Thayer.
Yeah. So I just wanted to talk about kind of everything going on. So coming back with a resolution that the public has not seen, I don't like the process. I think that we should have had something on the agenda that the public could review in advance so that they can comment. I want to figure out what is the process for the public to look at this resolution. And I also want to say that, the promise of the American dream does not depend on who's in office. And I'm very not happy about how this whole matter came to us. I think the best way to get the administration's attention for our $400 million is to go out and put this on the agenda when they have not come to us. They have not said that there's any issue with the resolutions that we've passed. Now, the Golden Gate Bridge is a symbol. It is a symbol for democracy. It is a symbol for diversity, inclusion. It welcomes immigrants who come in on boats, people who come over the bridge in cars. And for us to be, now looking at changing our policies of inclusion and equity and anti-discrimination, because, there's a different party in office, just leaves me with a very bad feeling that what will be next? What will be next? If the demands come in via executive order or resolution that say now we can't have other people, we can't write resolutions about policy that include other people, then where is it going to stop? And I know that that a lot of my colleagues want to try to fix it and come up with something, and I don't know if what is written is something that I will support or not. But I want to say I don't think this has been a good process. I don't think that we as directors, it is not a Hobson's choice. It is not $400 million or keep your principles and values. That is not the choice that I see that is before us today. I see that our lawyer just said that there isn't a legal thing making us do this today. And, I'm very disappointed that this was brought to the board in this fashion. And it seems like we're crafting something on the fly that the public doesn't get a chance to look at.
Okay. Thank you.
So I just want to conclude and say that, I know everyone's trying to make the best out of a situation that is not good. But I think getting to this situation without there being any federal action is what concerns me.
And I'll give you a response that probably won't be sufficient. I really appreciate your comments, Director. Certainly in the title, we can say we will denounce discrimination and affirm equality and justice. But we do have to remove certain words, in our opinion, before we can sign the grant, because the grant has a certifying that we don't have anything contrary to that. So they put the onus on us, and they can come after later and stop payments and claw money back. So I'll defer to legal counsel a little bit more on that, and then I'll come back to the other point you raised.
Yes, thank you for your comments. So the grant agreement does say that it's subject to the master agreement, and that a recipient affirmatively attests that they do not operate any DEI programs that violate applicable federal anti-discrimination laws. And to that end, as your general manager stated earlier, we could be liable for under the False Claims Act, and that could be brought by any third party, not just the federal government.
Then with respect to process, I apologize to the board. I wish I had the wisdom of Director Giudice, and so the original, information in front of you would have been crafted a little differently. That having been said, it's important to note a historical thing. we have a former director in the audience. The process we're unveiling today is the exact same process we used when we adopted the George Floyd resolution in 2020. In 2020, staff brought a resolution forward, and then the board said, we don't like that. And then staff went down the hall, staff rewrote it, we passed out copies, read it in the record, and the board approved it. So what we're doing today from a process perspective is something we've done before, and it's interesting that's what we did for the original resolution.
Thank you. I don't need to throw more information in or confuse it, but I don't see a significant difference in the way we've done business from the time that we signed that resolution, and my name's probably on the bottom as the president during that time, and what we've done in the last 5 years. I think this is an organization with great integrity. We care deeply about folks, and we have internal mechanisms if things aren't going right for individual people. That being said, I can relate to Director Tier's uncomfortableness in not having the public weigh in, although at this juncture I'm not sure that it's a public process. It's something the board has done to keep our funding. What is the downside from either of your points of view of going ahead and rescinding the original document, which is what's on the agenda today, so that Dennis can sign the papers today? They have to be signed by the end of the month. That's kind of the hurry on this. And then drafting that second resolution and letting it sit without a resolution for a month and then bringing it back.
I think folks probably I would feel more comfortable doing it all now. Yeah, I think we can take the words on this page that Director Giudice crafted and combine that with the original George Floyd resolution, which legal is poured over, so we know what are the problematic words, and bring something back that keeps the vast majority of it, but removes, race-specific references, which are, quite frankly, problematic for these grants. And so I think we could do that all today, and I think then people will feel better that they reaffirmed our values publicly, while they also acknowledge that we're going to move forward and keep all the money flowing, so we keep all of our employees engaged and employed, as well as all the contractors' employees that will be coming out here, after the end of the year.
Okay, thank you.
All right, Director Rabbit.
And thank you very much. And I think none of us are comfortable in what we have to go forward and do here. We're all involved in many organizations and entities that are dealing with this exact same issue. And I've had this exact discussion a dozen times, probably, all told. Each organization has looked at it in a different way, depending on whether they have a police force or not. I can tell you our own county was one of the first to join the lawsuit up in Kings County, Washington. I think we're the first 8 that were in there. We were successful to get an injunction or a temporary stay or whatever it's called on the issues that deal with homelessness and transit. And that was an important one for us because we had the same issue in front of us. We had a $7 million grant, FAA grant, programmatic FAA grant, by the way, that had that language in there. And it's totally unfair, nor were we ever going to ask staff to sign that document when we had those issues there. And as we sit here today, we have these 3 documents that we've passed for good reasons. I wouldn't ask anyone here to sign a document with that sitting there. That puts them at risk personally. It puts the district at risk big time. And while the programmatic permits, to me, the programmatic grants, are kind of a different matter than this particular, the federal grant that we're talking about, the discretionary, one of 2 in the country, as I understand, 4 total. Well, I know that Mitch got one and Nancy got one. That's fair. But this would go away in a heartbeat to a different state if we were to play hardball going forward. And I think from the public standpoint, I look at it as a leader on this board, as all of you are, from looking out for the public benefit of making sure that our bridge is secure for the next generation by being seismically upgraded in the fashion that we've all determined is appropriate. I do think that as we go forward, we're in for, as everyone knows, and listened to the news this morning, the latest Supreme Court ruling on the executive orders just ratchets it all up again. So as we do go forward, I look at this as an iterative process. This is not the last time we're going to have to deal with this. This is not the last time that we're going to have to deal with the wording that we're going to even put out today. And if so be it, if at some point in the future, I support changing the wording to allow staff to feel comfortable to sign the document, to receive the money. We could revisit that wording at some other point in time or have another meeting regarding our values. I agree that our values aren't going to change. This will still be an inclusive place to work, transparency, all the other things that we've just put in writing. But that was really, that was true before. It'll be true going forward. And I do support the motion that's on the floor.
Thank you. Any other comments?
I just had a question for staff. When you pass out the new revised language, could you also pass out on page, I think it's 2 or 3, the actual resolutions and language that you're asking us to rescind? I
Yes.
did not see that attached to the staff report.
Yes, we will.
Right, very good. We are now going to move to public comment. I have one comment card from the speaker in the House. Dario? Welcome.
Morning. The ground has shifted a little bit since I first thought of coming here with Director Giudice's suggestion. But I'll give you what was essentially my beginning speech anyway, and try to get it within 3 minutes. I don't envy any of you the position you're in, not the board, not Dennis. I'm going to go ahead and be as harsh as I think is necessary and say that we are living under a fascist and racist regime. And it would not make the demands it's making for us to retract public statements of our values if it did not serve its fascist and racist purposes. It has, unfortunately, the power of the practical, the power of the purse. We need what it has in order to do our jobs. And it knows that, and so it demands that we go along. The problem with going along under a fascist regime is that it has no bottom. There will always be another demand to go along. We don't know how severe, we don't know when it will come, and having gone along once, we would then have possibly burned our bridges with those who might be our allies when that next demand comes down the pike. And I remind you that there is that provision about cooperating with ICE among their demands now, and ask you to imagine what that might mean in the context of our work and how it might play out later. You're in an impossible position. And what I would ask is that you do the thing that allows you to look at yourselves in the mirror in the morning, now and in years to come, when you face those next demands, and to at least vote against the measure as presented to you today. And I look forward to seeing what comes down from Director Giudice's suggestion if you approve that amendment. Thank you.
Thank you. If there are no other speakers in the chambers, we will go on.
Thank you. Justine, I'm going to turn it over to you. I believe you have a speaker on your public line.
I do. Thank you. Good morning. Our first speaker is Alita Dupree, and if you don't mind, I would like to poll after Alita speaks this morning.
Sure.
So, Alita, please, thank you so much. Alita, please go ahead and unmute yourself.
Thank you. Good morning to the chair and members. Hope you can hear me. Alita Dupree, for the record, she and her with Team Folds. I wish I could be with you in person today. I really like being with you all in person. And I sent you a letter. I hope you got to read it. Not just talking about the specifics of the action, but also to give you context as to who I am. I admit that if I was sitting in one of your seats as a board member, I could not approve this. And I wrote about basic stories, about the ideas of schoolyard bullies. That, well, when you give the money to the schoolyard bully, they're only going to come back.
I bet they don't know.
What next? What next? And I'm not a protesting kind of person. You won't ever see me in the streets. I believe that disputes are best settled in courtrooms where we have advocates who can make the case. But what about those, the many who are different? I mean, we are a community institution. What are the practical effects of rescinding these policies? These policies were enacted to bring about concrete change. These are not words on paper, but really about bringing out concrete change to further the work of our district. So upon repeal, if it comes to that, what are the practical effects for those of us who use the services and facilities of the district? I hope that I'll always be welcome in your meetings, and I'll always be welcome on your buses. At a minimum, I pay the fare and follow the rules of conduct. Yes, I'm different, but this is an institution that serves everyone who respectfully engages. So I am concerned about the future of our district, that in rescinding these statements, what about our reputational risk? And yes, what's happening out in the world is transactional. And I saw what happened at Washington Metro. I think they rescinded some things. Now, what's going to happen to reduced fare policies? Are buses eventually going to be segregated? Can people be denied entrance to your facility simply because of who they are? That is why this is so concerning to me. I can see this is hard for you. And I've known Dennis for a very long time. And I always enjoy conversing with Dennis. And I consider Dennis to be a friend. And that's not going to change. And I consider you all to be my friends. And that's not going to change. I know this is hard for you. And I'm not a grandstanding type of person. But the thing is, I'm concerned that if we repeal this, it's a form of capitulation. And the schoolyard bully is just going to come back. So ask yourselves, how would you feel? I think you are asking yourselves that. And I respect all of you. I just want all of us to be able to enjoy the world-class service that district has to offer and not live in fear. Thank you.
If I may, I just want to thank Alita for her comments. I'm a big fan. You're always very thoughtful. You are welcome here. You will always be welcome here. You're always welcome on our buses, on our ferries, which you don't ride enough, as well as on our bridge. So thank you for your comments.
Justine, why don't you go ahead and poll again, just in case there's other people who joined that may want to speak.
Certainly. I'd like to see if anyone new has joined us that would like to speak this morning. Please use ** to unmute yourself and give me your name, and we'll go in order. So if you would like to speak, please press ** to unmute yourself to come through the system and give me your name. Again, if you have public comment, please press ** on your device to come through the system and give me your name. Madam Secretary, I'm not hearing anybody else this morning.
Thank you.
Okay, thank you. So we're going to close public comment now and bring it back. We had a motion by Giudice and a second by Garbarino for an amended resolution to come back to the board at our board meeting today, that the staff will take the language and the input received by the board of directors and work with legal counsel to craft a revised resolution. Is that correct? Yes. Okay, very good. So we'll take a vote now. And may we have a roll call vote, please?
Sure can. Thank you. We're going to do a roll call vote on an amended motion. Catherine, should we take a vote on the accepting the amendment and then take a vote on the amended motion?
Yes, let's go ahead and do that, please.
Okay, just for the record, so we're going to take a motion to amend the original. So this is going to be accepting the original amendment. And before we actually vote on an amendment, if that makes sense.
So that's to accept what Director Giudice recommended. So that's what you're voting on. Do you accept changing what we have in the staff report to accept what you have?
Got it.
Okay, I don't think that so we're now voting on accepting this language that he just read? Is that what we're doing? Or are we voting on accepting the idea of amending a motion?
The latter. The idea of amending the motion.
The idea of amending
The original motion.
okay.
The original staff recommendation.
Thank you.
Okay, sorry about that. Okay, so that's what we're doing for the first vote, okay?
Okay.
Thank you. We're going to start with Director Devlin.
Aye.
Aye. Ingardio is absent. Garbarino?
Aye.
Giudice?
Yes.
Hardiman?
Aye.
Hernandez is absent. Maston?
Aye.
Moulton Peters?
Yes.
Parr?
Aye.
Parrish is absent. Rodoni?
Aye.
Sauter is absent. Snyder?
Aye.
Fear?
Aye.
Second Vice President Rabbit?
Aye.
First Vice President Hill?
Aye.
And President Cochran?
Yes.
Thank you. The vote is unanimous. You have 12 ayes.
Okay. Then we have
13.
13.
Yeah, 13.
And now we are voting on accepting the wording offered by Director Giudice and other comments and having legal counsel and our general manager staff work to incorporate them into the final resolution. Correct?
Would you like to read?
Sure, yeah.
And
And it would be a motion approved conditional on the additional terms discussed during this meeting to be brought back before the full board and presented to the public.
Okay, again, so now we're voting on the language that he just read. Is that right?
Well, it will come back in a revised form to the full board.
Why don't we just get the language back and then vote on it at that time? We just voted to allow him to do the language and come back to the board
We are moving it to the full board, Director Thier.
right now.
Yes.
Okay, then I have a comment. If that's all right. Okay, so I voted yes to allow the language to be revised and to come back to the board. That is in no way in support of the process. On this next vote, I will be voting no. I don't think we should be approving something we just heard without seeing it in writing and without having the benefit of seeing what we might be rescinding. I also want to ask, are there letters that came in from the public? Because I did not receive any, and I would like to see those as well before I vote on any vote anymore during this process.
We received 2 emails, and I received personally 1 late night voicemail, all in opposition to the staff recommendation.
Great. Could we also pass out a copy of those?
We just received them before the meeting, so I'll have to make sure I print a copy.
Okay. Or just email them.
Sure.
Yes. Thank you.
Order.
Recommend.
We're taking 2. We're taking 1 vote. We're going to take a second vote, but I've only heard 1 motion.
So we will take another, we'll ask for a motion on this next.
Okay.
We'll ask
I thought that's what the original motion was.
Okay. For clarification, could counsel read?
I was going to say, I thought Catherine gave us words for.
Sure. Yes. The motion would be to approve the staff recommendation contingent on the additional terms that were discussed during this meeting to be brought back to the full board for consideration.
So moved.
Thank you.
Second.
Okay. Moved by Giudice, second by Garbarino. May we have a roll call vote, please?
Thank you. We'll start with Director Devlin again this time.
Aye.
Guardia is absent. Garbarino?
Aye.
Giudice?
Yes.
Hardiman?
Aye.
Hernandez is absent. Maston?
Aye.
Moulton Peters?
Yes.
Parr?
Aye.
Parrish is absent. Rodoni?
Aye.
Sauter is absent. Snyder?
Aye.
Fear?
No.
Second Vice President Rabbit?
Aye.
First Vice President Hill?
Aye.
And President Cochran.
Aye.
Thank you. The motion passes. You have 12 ayes and 1 no.
Okay, thank you. That motion passes. We will now move on to item number 4, which is to approve an amendment to the rules of the board regarding meetings, Rule 2, Section A, and the district secretary will present this report.
Thank you. At the request of the president, we looked into the rules of the board, and just to give you a background, we have 2 documents that kind of are guiding light here at the district. One is the rules of the board, and one is the master ordinance. Rules of the board is kind of the board's own policies. And then the master ordinance is how the board puts in the policies and asks staff to implement the policies the board puts out. So that's kind of the really high level explanation of the two policies. The purpose of the rules of the board is really to facilitate the handling of the district's business by the board. And we attached a attachment to the report and the rule 2 of the rules of the order in regards to meetings. And it currently permits the meetings of the board to be held by teleconference and allows directors to participate in meetings remotely as permitted by the Brown Act and authorized by state law. And then interest in remote participation has prompted a review of the rule. The Brown Act provides 3 optional methods for remote participation, but it doesn't mandate that the agencies make these options available at all times. There's the Brown Act's traditional teleconferencing option for the director to participate in the meeting from a remote location by phone or video conference if there's requirements that are met or satisfied, and they're listed in the staff report. Then there's different statutory requirements apply when the director wishes to utilize the Brown Act's 2 other remote participation options based on just cause or emergency circumstances. And that's part of the government code as well. So to participate remotely under the traditional teleconferencing rules and to provide sufficient time to prepare all our meeting materials, we're asking to amend Rule 2A as stated in the recommendation. And that's really to allow us time to post everything, to make sure that we have the locations all properly vetted, to make sure that we allow the public to participate as we're supposed to. And the other thing is also to accommodate directors under the American Disabilities Act as well. So those are kind of the high level of the staff report, and we're available to answer. Did I miss anything, Catherine?
Questions from the directors? Directors here.
Yes. So under the indent 1 on the proposed language, the 9-day notice, is it possible to add unless in event of emergency, or does because there may be a time when a director might be sick or go into a hospital, they may not be able to give the 9 days notice. And obviously 9 days notice is reasonable so that you can prepare to set up the telephone conference.
Right. And that makes sense. And yeah, you know what? Maybe we have to look at it on a case-by-case basis just because this is kind of a general statement for how we're going to conduct it. If there's an emergency, then we would look at the emergency circumstances that are involved in the other parts of the rules.
Okay, so maybe that should just be
that could fall under
and refer to another rule. Because the reasonable accommodation is a little different, I think.
Correct. So there's the other different statutory requirement that allows us to do it for just cause with emergency. So that kind of falls under that one too. We would review the emergency circumstance.
Okay. And then the other question that I have is, so the Brown Act is pretty clear about when directors can and cannot, I'll call it the old Brown Act. And I'm wondering, do you think that this narrows a director's ability to participate?
Yes, it does.
Via telephone? And what were the reasons for doing that?
The concern is that if a director is participating remotely and you drop off the call, we should then technically stop all the district's business. Because in theory, by the Brown Act, the public should be allowed to participate at every meeting location. And if the public's not allowed, you're not supposed to continue with the decision-making process. And there is some risk allowing remote participation. And so, the president thought that we have 19 members. If we have 10, we can do our business. That, the risk of losing a director, which can happen at a remote participation, is something that we want to minimize to the extent that it makes sense for us to get our business done. We meet once a month. Yesterday we had 3.5 hours of meetings. And so the concern is that once you notice location, it has to stay available to the public for the totality of the length of that meeting. Otherwise, the meeting needs to cease. But it's a straight policy call. The board can choose to do it or not do it.
Yeah. So I think that what's going into my mind is that I'm not sure that this is even legal.
I think that the Brown Act sets forth very specifically that directors can appear via teleconference with the certain exceptions and rules. There are bodies throughout the state of California that operate under the Brown Act and operate successfully. Meetings aren't canceled, and meetings go forward. So I don't think it should be in the discretion of one president. I don't think it should be in the discretion of staff whether a director appears at a board meeting. I do think that we should have some rules, internal rules about how much time in advance notice as a courtesy to district staff so that they have an opportunity to ensure there's a quorum and ensure that the remote participation is all set up. That is also required by the Brown Act because you have to publish the agenda with the location of the director that is attending remotely, and you also have to post it, and it has to be a public location where the public can come. So even if a director dropped off the call, the public could still be there. So I don't think restricting the Brown Act is something that I could support. I think that there's a reason why it's there. I think we want to encourage participation, and especially if one of my fellow directors had an accident, God forbid, or a medical emergency, but could still participate, I would want them to be able to participate fully in the board, and I wouldn't want to restrict their ability to do so.
Please, Catherine.
Yeah. Thank you very much for your comments. Our office has reviewed this and was involved with drafting the language, and I can confirm that the board does have the ability to further restrict the Brown Act in this way. It is a policy decision, as your general manager said, so ultimately it's up to you whether or not you would like to, but that is permissible. And to reiterate on the second page of this board report, it does have the language that mentions just cause or due to an emergency circumstance. I think those are very valid concerns raised by the director. He did make sure to include that language so that in the event that there was an emergency circumstance, that would be accounted for.
Okay, any other director questions or discussion? Yes, Director Rabbit.
Yeah, supporting going forward. I could just give you the experience that we've had more than once, especially at ABAG. And I drove from my house into the city to go to an ABAG, and there's 31 members on ABAG. We had 7 remote locations. One person did not show up, in spite of the fact of being having everyone at every other location, and probably a dozen of us down at 375 Beale. The meeting was canceled, and so we need to avoid that and restrict accordingly. And, you know, the part of the problem on the public access at those remote locations, if someone drops off, you have no ability to know if the public has access or not. And half the time it's someone on a personal computer at a residence, even though it may be posted fine, they don't truly have access. And it's a good reason to further make sure that we are compliant with the intent of the Brown Act by fulfilling these, this piece that's in front of us.
Any other comments or questions before we move to public comment? Okay, I'm not seeing any. Let's move to public comment. I don't see anybody in the chambers.
I do not have any cards for speakers in the room. I'm going to turn it over again to Justine. Justine, would you like to check your public line to see if there's any speakers on this item number 4?
Certainly. Is there anyone that's joined us that would like to speak this morning on this rules item? Please use ** to unmute yourself and let me know. Okay, I'm not hearing anyone for this item. Thank you.
Thank you.
Okay, we'll bring it back. Is there a motion, please, on agenda item number 4?
So moved.
Second. Okay, moved by Giudice, seconded by Park.
All right. I can do a roll call on this one too. All right. Starting with Director Devlin.
Aye.
Engardio. Is that it? Garbarino.
Aye.
Giudice.
Yes.
Hardiman.
Aye.
Hernandez is absent. Mastic.
Aye.
Walton Peters.
Yes.
Parr.
Aye.
Parrish. is absent. Rodoni?
Aye.
Sauter is absent. Snyder?
Aye.
Thier?
No.
Second Vice President Rathod?
Aye.
First Vice President Hill?
Aye.
And President Cotter.
Aye.
Thank you. The motion passes 12-1.
Thank you. That motion carries. Okay, and with that, we have public comment under item number 5. Is there any public comment on items not on the agenda?
We have no other speakers for this committee.
All right, with that, we are adjourned. Thank you very much.
The board meeting will probably start a couple minutes late.